Hi.
Hi.
Welcome. We're back with Wine and Realty 614.
I'm Amanda.
I'm Jenny.
And I'm Brent.
Brent's here.
Special guest star.
We're all here. So one of the things that has been very interesting to me is there are some things with real estate that are maybe not as positive in the buyer or seller experience. And when that happens, they tend to get angry and maybe hire an attorney. And I will preface this whole episode and every episode hereafter by saying we are not allowed to practice law.
Right.
We are not attorneys. And I am in no way commenting on the legal aspect of this. I am merely bringing you a story. And we'll hash this out as people in the real estate business.
I always want to make a post on like a Facebook or something and ask like, what's the most popular phrase in your industry? And I think in real estate, it has to be, I'm not an attorney, because everywhere you go, everybody has to protect themselves and say, hey, I'm not an attorney.
So what's interesting to me in Ohio is that you do not have to have an attorney helping you with the purchase. You are completely allowed to hire someone if you want. However, and I only speak from my experience in Chicago because that's where I'm from and purchased a home there. You do have to have an attorney involved. So it's you know,
one of my clients actually, he hired an attorney because his family was from Chicago and they told him he had to.
And that's you had to there. So
Yeah.
it's just kind of an interesting. Now, we do always start the transaction by saying that the contract and the forms that we do send to clients when they're purchasing or
They're
selling
written by
to them,
attorneys.
They're written by attorneys.
Yeah.
And they're you know, we all as real estate agents are provided to them by the Board of Realtors and
The Columbus Bar Association. So all these standard forms that the Columbus Board of Realtors has, it goes through a full review process with their attorneys and then goes to the Columbus Bar Association and gets endorsement through the actual Columbus Bar Association, and it gets reviewed on a regular basis.
Yeah, so you don't have to in the Ohio. Well, I don't know all Ohio, but in Columbus, which is our experience, you don't have to hire an attorney if you do not want to. You can, and you have the right. So, with that all being said, now we're getting.
I was not told like what this was, so I need to know.
This is what makes this episode fun, and hopefully, if it's interesting to everyone, then we will continue with this kind of thing. I don't know.
You'll get surprised next time.
That's it. So that's it. So
I
Amanda will
surprise her.
have to do the research next time, and I won't know. But what we are talking about today, well, let me ask this. When you are, we're going to get, and maybe be careful about how you answer. When you are sending forms, say a residential property disclosure to a client, or when your client is filling out a residential property disclosure, do you review that prior to them? Say, let's do it from the buy side because that's where one of these cases is from. Do you read the property disclosure prior to sending it to your client?
Briefly.
Yeah, I do as well. Quickly.
I think it is their responsibility because I cannot tell them what they are going to be worried about.
Right.
They need to read it.
So what we're talking about today is negligence. Okay. And if a real estate agent, broker, can be in trouble for negligence get sued and be responsible for something maybe the buyer didn't know or didn't see.
My quick answer is no.
Yeah, well, I think that, you know, liability.
And that's the end of this episode. Thank you for
Goodbye.
joining.
This is over.
Well, liability is a huge problem in today's society. I mean, you can get sued at any time for anything, right? Absolutely. So the National Association of Realtors has on its site a bunch of cases that, you know, they may not be timely. They're not anything that has happened, you know, in the recent past. But one of these cases that I found was interesting was now in this the sales rep was not was not held responsible for. I have to put you away. It's too much. So for those of you maybe just listening, we're also going live on Instagram, and it's just a lot to try to concentrate on what I'm talking about and hold the camera. So anyway.
And listeners should probably follow on Instagram as well. What's that?
Yeah, so there is a Instagram account called Wine and Realty 614. Follow us there, and you will get live video and pictures. And
more content.
Gram. It's the Gram stuff. So anyway, getting back to this. There was a MLS listing. Wait, no, hang on. There was a team in Texas sued because they had given their buyer the residential property disclosure. Mm-hmm. And on the residential property disclosure, the seller had indicated that, yes, there was water issues with the home, but they didn't complete it. They didn't fill out the portion that's, you're supposed to describe the problem on. And as the real estate agent, they didn't tell the buyer that portion needed to be filled out. So when the buyer completed the purchase and moved into the home, and they had all these problems with the house and flooding, and there was erosion, and it had been a flooding problem for a significant amount of years.
Whose fault is that?
Well,
I was going to say, that's
ultimately the lawsuit.
Question,
yeah, so that is the lawsuit. So now,
I'm more curious about which agent got sued on which side.
Yeah, it was the buyer's agent, the buyer's broker, and they're the ones who got sued because the buyer didn't know that portion was supposed to be filled out. It just indicated, yes, that there was a problem with flooding, but it did not say what the flooding was.
I'm surprised they didn't bring the listing agent in as well, saying that they didn't.
Well, yes, it was, but they didn't know that.
How could they not know it was a flood zone? Because
was it a cash deal?
No, the buyers
they have to have flood insurance.
This was okay. So I should say this is in Texas, which is different than Columbus. And this was a long time ago too. So
interesting.
Yeah.
So now you have to have flood insurance, and I think I always tell my clients when I'm listing a house, I'm like, tell everything that you know, because if you don't, your neighbors will. I mean, it's true.
Oh, and how many showings have you been on that a neighbor has come out and starts talking?
Your neighbors are going to talk.
And spilling the tea.
If you have someone out to your house for an issue, and they have already been out to your house for an issue, they are going to tell the new buyers, and you will get sued. You need to disclose everything. And so I guess getting back to what you're saying, like, I don't know who's liable for that. Like, as a buyer's agent, or as a seller's agent or a buyer's agent, like, I'm not responsible for reading the issues with the property that you're buying and telling you that you should be not okay with it.
Well, I think that there have been times where I have been on the listing side and the buyer's agent has said, this is not filled out properly. Mm-hmm. And so then I go back to the seller and say, look, can you fill this out properly? And, to be quite honest, the property disclosure is kind of hard to keep track of line by line by line. There's a lot going on there. And sometimes as a person filling it out, they would miss something.
Yeah.
In this case, they may or may not have missed something. I mean, you don't know.
I think that the seller should only be held reliable.
Well, yeah.
Because they say, like, in the property disclosure, it says, like, check yes or no. And if no, explain why.
Well, and so they didn't.
Yes, explain why.
But they didn't explain why.
Yeah.
And the court ended up ruling. So it goes through a series, and then gets thrown back to the small claims court from the bigger courts because they were like, it's got to go back there. And ultimately, the court found that the buyers were first-time home buyers, and there's no way that they would have known that portion should have been.
It says it. Well, I guess I don't know in Texas.
I was going to say the form may be different.
It says if no or yes, why?
Right.
Yeah, but. Okay, with that being said, how many times have you sent the paperwork?
How many times have you filled out a form?
How many times have you sent the paperwork to someone And, you say, as agents, make sure you read what you're signing.
Right.
And they're not. Because the ding and the ding and the ding and the ding happens that they signed.
If you do your due diligence on that, whose fault is it really? It's really the seller's fault because they didn't explain why. They should have explained why. It says if yes or no, explain why. I mean, how many times have you been in a doctor's office and like, is this what's wrong with you? If yes or no, explain.
Well, and to be fair, it doesn't say if the sellers were also sued. They may have been.
Yeah.
But in this case, it is the real estate agents.
I'm sure that they were sued.
You would hope.
I would think, yeah. I mean, that's just not, I don't know. But it's something for us to think about that.
I'm still amazed that a lender wouldn't have caught that it was in a floodplain because that's their investment,
well,
right?
they also had an inspector come, and the inspector did not accurately indicate what the flooding lines were from either.
I don't know that it's fair to an inspector, though.
I mean, isn't that what we hire them to do?
Yes and no.
That's an interesting question on if an
inspector
brings that in. Yeah.
The way this reads is additionally the seller's disclosure form left unchecked boxes concerning improper drainage, present flood insurance, located in a 100-year floodplain, or located in a floodway.
If they didn't,
hang on. An inspector discovered water markings in a crawl space, but incorrectly opined that those probably came from a leaking water line.
How would they know? How are they supposed to know?
I don't know. Any inspectors want to comment?
Inspectors are not supposed to be researching the house.
I mean, but
that's what we have title for. We have lenders for. Like those are, and that's what we have the seller for, to disclose information like that. Like I completely disagree that the inspector should be held liable.
Well, it doesn't say the inspector was liable. It just says the inspector didn't correctly indicate what the flooding was from.
Between, I think it's like the listing agent, but like, how would the listing agent know? Like I didn't get a listing once because I saw water running through the basement. I was like, you have to disclose that. And they got upset.
I showed a house once that had water running through the basement. And I was like, you can't buy this.
They were like,
this is
my
a major
seller,
problem.
The potential seller was like, well, that's never happened before. And I was like, I understand that, but I see it and you have to disclose that.
Sure,
I didn't get the listing.
Happened before.
I didn't get the listing.
Yeah.
I wonder why.
I wonder why. So one of the interesting, I know when it comes to filling out the property disclosure on the real estate, on our, like if we were the seller's representative, we should not be anywhere near the seller filling that out.
No.
That
I had a seller asked me to fill it out once. I was like, absolutely not.
No. And they ask questions like, how should I answer this? How should I answer that? And it all comes down to you answer to the best of your ability.
Knowledge. Yeah.
Or ability.
Sounds like you've said that a couple times before. As you say in unison.
Yeah. What I will say is liability is a huge thing in this industry.
Absolutely.
Right?
I don't want to get sued.
So there is another case to chat about briefly. And it is, again, inaccurate MLS information having to do, ironically, with the property disclosure. And actually, this doesn't, but I would imagine this would. Hang on. No,
just
what I would, because in my head, this is a question that's on our property disclosure. So I don't know that this may or may not have been on the. Anyway, it has nothing to do with that. What it has to do with is the information that's in the MLS. And this house was incorrectly, the agent incorrectly entered it as saying it was on city sewer. It actually had septic. And again, the inspector did not say it was on septic, which I would think.
Do they know? I mean, do they know, and did the buyer acknowledge what they told them? And you have to pay for a separate inspection
here.
I was going to say, what state is this in?
Yeah. So here, you have to pay for a
North
separate
Carolina.
inspection.
This is
so
North Carolina.
Here, if you don't pay for that, then that is. There's nothing that they can say.
Well, that's a newer law here, though. That is not.
No, it's not.
Yeah, it is. It's only in the last few years that it is required to have a septic inspection.
It is. It's not required. That is optional. Well and septic is optional. No, it is. It is optional.
I think
it is optional. You do not have to have it done. I recommend that you have it done.
Well, any inspection is not required.
If that is listed wrong, that is completely on the listing agent. Like that's not anybody else.
Okay.
And so that's not fair to the buyer. That's not fair to the inspector.
This was voted no liability. toward the
So who was
MLS
actually sued?
information.
So the listing agent was sued.
So the listing broker